Mr. Pierce, I'm assuming because you're here by yourself, you have not obtained any counsel, attorney?
Sir, I'm surprised to hear you mention the assistance of counsel issue mentioned without the obvious prior knowledge that battle back and forth that you and I have had over the last year of this issue, the assistance of counsel issue. There's a record on the court case net on April 2nd of me requesting assistance of counsel that I have secured, and they would like to appear via WebEx or the internet like everybody did in COVID for 2 or 3 years, and you denied that. I'm standing here without the assistance of counsel. I have a right to assistance of counsel, but enjoy no assistance of counsel. In fact, part of the motions that I brought here today, something I just filed not 20 minutes ago, was something that I would like the ability to stand in court order where I can record all audio inside of a courtroom, because I'm having to use ChatGPT as assistance of counsel, because I'm here facing all these charges in this system with no assistance of counsel, no law degree, no bar member helping me whatsoever. This has been an ongoing issue. That's why I'm surprised to hear you mention it so casually.
I'm not mentioning anything casually. The answer to my question is you don't have an attorney. I've given you a lot of time to get that done.
I have an attorney, sir.
There were 2 lawyers that even volunteered their services. I don't know whether you talked to them or not, but
well, sir,
and I understand the difficulty in that.
In open court,
I'm not going to go back and refresh the prior ruling about appearing by WebEx. I don't like to do that, especially for a jury trial, and that's why I denied those motions.
So you're denying me the right to assistance of counsel, sir?
No, not at all. The court has given you ample time.
Sir, I know.
Second thing.
Sir, I explained last time. If I can just
let me finish. You keep interrupting me, and that's not a good idea. Sir, what's your name?
I'm trying to.
What's the last name?
Campos, C-A-N-P-O-S.
Line 8. Okay, just sit tight. Yes, Mr. Pierce, the last time we were here, you had filed 5 motions, 5 motions. I have those noticed up for today. I think we should take those up because you wanted to be heard. Now, a couple of them, I reviewed them briefly this morning. Some of them regarding...
Sir, before we move on to the motions, can I just please finalize our addressing of the lawyer issue?
Sure.
Okay, because you mentioned the last hearing, and I just want to state on the record that last hearing, yes, I agree. 2 lawyers randomly spoke up in the middle of the hearing and offered their services to me for quote-unquote whatever I'd be willing to pay. I then asked them, great, and I would say I would accept the assistance of this counsel if they are not required to quote-unquote represent me, which means completely dominate everything about the case according to this court. Meaning, if you wanted to use your power to hypothetically have me removed because you didn't like what I was saying, you could address the attorney who's quote-unquote representing me, and to this courtroom, that would be me. And you could find guilty and proceed with all manner of abuses of power, and I would be out in the hallway completely unable to defend myself. And it's only because of that rule that I don't want an attorney to quote-unquote represent me. If they want to be standby counsel or whatever term this court with all the power it has uses to say, hey, they can serve as assistants of counsel like it says in the Bill of Rights, everybody here would be happy. I have shopped for, go on Google Maps and look for the 6 closest criminal defense lawyers to this building. I've called them all and I've got answers from them all, and they all will not take the case because they demand that they have full power of quote-unquote representing me. Given the allegations of abuse of power that I've had in this entire proceeding over the past year, one could reasonably understand why I would not agree to such an agreement. That's the issue on the lawyer. I still stand here without assistance of counsel. I have ChatGPT I would love to use for assistance of counsel, and I would consider that and sign documentation that fulfills my assistance of counsel. But in order to use that, I need a laptop capability in here, and I need it to be able to audio record, because it can hear, the technology is such today that it can hear a voice, immediately live transcribe it into written words, and then when you're finished speaking, it will text out a recommendation of what I could say. I will then choose whether or not to say that and respond accordingly. Now, I know this is the first time ever technology being proposed in a courtroom, and I'm proud to be the person to make it, and I'm happy this is being recorded for the record. I am standing here without assistance of counsel. I humbly and respectfully request that ChatGPT be allowed to be used as my assistance of counsel, and that the court provide the technology and hardware in this building to do so in the future. Thank you for listening.
Appreciate it. This is State have any response to?
Yeah, Judge, I mean, there's so many problems with the AI in the legal world right now. It's not trustworthy. It makes up, false case law, goes off of false rules. I don't think it should be authorized for the courtroom. I don't think it's ever been done. I don't think it should be done on this case. That's really all I can say, but...
Okay.
May I allow a response to?
You finished, Mr. Murphy?
For
Go ahead, Mr. Pierce.
Lawyers have been caught by the hundreds and thousands by judges in this country in the last couple of years using large language model programs in the performance of their duty. Those who have not been caught have not been caught. This trend of, and may I correct Mr. Murphy, I am proposing the use of a large language model. This is an LLM. This is not AI. This is not artificial intelligence whatsoever, even if it claims to be so. Large language models simply predict the next word that makes logical sense according to the ongoing conversation. Now, I immediately, this year, as soon as ChatGPT came available, I immediately started paying it money and using it as assistance of counsel. All of the motions that have been filed in the CaseNet under my name in this case were heavily influenced by ChatGPT. So whether or not the court wants to recognize it or say, oh, it's new technology, we are not going to do it, I have been using it. I am claiming for a fact, under penalty of perjury, that I have been using it all this entire time, and that it has been extraordinarily effective. The claims that Mr. Murphy makes about it using fake CaseNet, I understand why he would say that. And because I've trained myself so well with the use of this program, and it has trained itself to me, I can instantly recognize anytime it does any of these tactics that he's worried about. They don't come out of my mouth because I'm obviously the final decision maker on what I say and what it doesn't. I'm perfectly well educated on how it operates and how it can make things up. Believe you me, it's my precious time, all these hours that I've used in preparing myself in my defense for this case, and another, by the way. So I am simply stating that I would like to use something that is available to me and the court could provide it easily. I am facing up to a year in jail for a dog attack, and I've claimed all along this dog did not have a ball in its mouth.
Judge, can I respond?
Sure.
Not only would he be using that in the courtroom during trial or whatever else, that app is recording everything that's going on here. We don't know what data it's taking. We don't know where all that's going to go after this, and just it being practical here in the courtroom. Are we going to have to wait until it absorbs all the information?
No.
Spits out whatever it processes and tells him to say? It's just not efficient for the courtroom. He's had ample opportunity to get an attorney.
I just said they won't accept the case.
Okay. Okay, so a couple of things before we get started on the motion. There's a couple of things you said, Mr. Pierce. You said you wanted AI as an aid and as an attorney.
A large language
in the
model.
courtroom so that it can help you in your defense of this case.
Not AI, sir.
The whatever electronic means you're intending to use, those are not licensed attorneys. I'm not going to allow that in the courtroom. If you want to use that as your legal research, you can use whatever you need to use.
Sir, I'm not a licensed attorney.
And as far as attorneys go, it sounds like you have the means to hire an attorney, and
I do not.
find one that would only do this as a reference or guide.
I do not have money to hire an attorney.
Excuse me.
I'm sorry.
I didn't interrupt you.
You're correct. I'm sorry.
So we're going to proceed with the motions today that have been filed, and you can add those on file. What I want to know is, beginning with the first one that I have written down, motion to compel exculpatory evidence, that's your motion, Mr. Pierce.
Sir, I don't have money to hire a lawyer. If I could hire a lawyer because one would accept my case, I don't have the money to pay them. Part of the motion I filed this morning is I would really like to have the $2,500 that I had to pay to get out of jail back to me. I have ties to this is written in the motion I filed this morning. I've been coming to every hearing for a year. I am no flight risk whatsoever. I have stated all along I am going to fight this to its conclusion and file a federal class action lawsuit at the end of it. I'm not going anywhere. I'm behind on rent. If you want me to hire an attorney, it would help if the government would give me back the $2,500 cash.
Well, I don't have that motion in front of me. If you say you filed it and
I have a copy of it here.
No, I'm not going to take that up right now because he needs time to prepare and review that, and we don't have that on the agenda for today. Yes?
Judge, she's saying now that he can't afford an attorney. I mean, he could have an indigency hearing, if you see that if the public defender could represent him. It sounds like he doesn't want to proceed on anything.
Is he?
You're free to apply downstairs if you're...
Is he not listening to a word I'm saying?
Let's not
I can't have a lawyer represent me, and you're saying you don't want to have ChatGPT because it's not a licensed lawyer. Sir, I'm not a licensed lawyer, and I'm defending myself alone without the assistance of counsel that is guaranteed to me in the Bill of Rights.
I understand that.
I can't afford it, and none will accept it.
Given you ample opportunity
But how?
Many months.
They won't accept the case, and I don't have the money to pay.
They won't accept the case because it sounds like you want them with a condition that they not take...
A condition that I've had countless other...
Lawyers don't want to do that.
I've had many lawyers working that way under me. With the judge's permission, they allowed them to work that way under me.
You're allowed to file whatever motion you filed, and if you did, then we'll take it up if it's filed in accordance with the Supreme Court rules. One of the motions you did file is a motion to compel discovery of exculpatory evidence / Brady request. Sir, that's your motion?
Sir, let's structure some organization. You're pulling out a random motion. Now, I have 4 motions filed from July 7th, and I have 3 motions that I filed on August 28th. I have hard copies of all of them here, and I'm wondering, which one are you pulling out randomly and why? And I would further...
I'm pulling out the motion was filed August 25th, 2025, the motion to compel discovery, a disclosure of exculpatory evidence, parentheses, Brady request.
Allow me a moment to collect it.
Certainly. Filed on August 25th.
Your Honor, I don't mean to interrupt, but while we're taking a short break while he gets his stuff in order, Mr. Campos has indicated to me that he's just looking for a continuance to speak to a lawyer. Is that something I could write up for you?
Sir, that's on that memo that the officer's going to give you. You're free to go.
Thank you, Judge. I apologize for the interruption.
All right. You ready, Mr. Pierce? You got it?
Yeah, I see the motion filed here. And the motion that carries precedent over all these motions is the verbal motion, and the motion to dismiss that I filed on July 7th. It's a motion to dismiss because of the state's improperly filed case.
I'd like to take up the motion to compel disclosure of exculpatory evidence filed on August 25th so we can maintain some...
I appreciate you saying that, Judge. I respect it. I'm simply informing you that the motion to dismiss all charges takes precedent because if it is granted, then this motion is all moot. It wouldn't matter at all. It's a complete waste of time to rule on it. We need to address motions that dismiss all charges entirely, get through those, and then go through motions that presume that the case is going to continue. And might I add really quickly, I find it really unfortunate that the court decided to schedule a pretrial conference and 2 days of a jury trial, knowing that this motions hearing was scheduled for today, knowing that several motions were to dismiss all charges. It seems presumptive of the court to presume that everything's going to be dismissed, and they just go ahead and schedule these times and places without my input whatsoever, what's going on convenient to my life. Do you see what I'm saying? You've scheduled a trial with a motions hearing today with motions on the record to dismiss all charges that in the courtroom of public opinion would wildly succeed. This is all foundationally built on the opinion of one woman and no other evidence whatsoever. I just got done reading the complete police report. You have a witness I've never heard of before who's claiming to actually have seen the shooting. This police report mentions a work truck by a neighbor that has video camera of the incident himself, and that they just need to get the video from the company.
Hold on, you're talking...
This is exculpatory evidence, sir.
You're talking a lot here, and you need to slow down for a second. Your request is for the court to take up your motion to dismiss on July 7th. That's the one you want to take up first.
Yes, sir. I have it here in my hand.
All right. Mr. Murphy, you have the July 7th motion to dismiss for lack of credible evidence.
No, this one is called a motion to strike and dismiss complaint and request for full finding of fact and conclusions of law. This is the one I filed initially, pretty much on day one, once this case really started.
Let me make sure I have. All right, filed on July 7th, labeled motion to strike / dismiss complaint and request for full finding of fact and conclusion of law.
Yes, judges have seen this motion for 12 years straight, and I won a case on it that threatened me with a year in jail, and they admitted the prosecutor didn't have jurisdiction.
Mr. Pierce, let's,
Hilo, Hawaii, you can look up that case.
taking up the motion filed on July 7th, motion to strike, your motion, you can proceed, Mr. Pierce.
Another judge has granted this motion.
Okay, Mr. Pierce, you may proceed.
What do you want me to proceed with?
Your motion. I have the written file.
My motion stands on its own. The words
You
are...
wanted to speak to
Have you
yourself.
read the motion, sir?
You don't get to ask me questions. It's your motion. Do you want to add anything to your motion? Do you want me to take it up as it is?
You're a judge ruling on the motion with power, and you're saying you don't have to tell me if you've read it or not?
I've read everything, Mr. Pierce.
You have read the motion?
Yes.
Okay, thank you for that
It's
answer.
your motion. Do you want to add anything to it? Do you want the motion to stand on the pleadings, or how do you...
For fear of my words being used to replace the words in the motion, and then you strike down my words, I will not add words to it. I will allow it to stand on its own, and I predict that you're going to not only deny it, but you're not going to give me grounds and reason for your denial.
Okay, you want it to stand on your own. Okay. Mr. Murphy, do you want to respond to the motion, if anything? This is the July 7th motion to
I
strike.
can just go briefly, point by point.
On this motion.
Let's do it.
This motion only, go ahead. If you have objections to it, why I shouldn't grant his request.
Yeah, Judge, this first argument here in paragraph 1, it says there's no case, crime, or cause of action. Well, actually, Judge, there's a charge of animal abuse that has been filed, and our office has filed charges, and part of his argument is that the basic elements of a case or cause of action is a violation of a legal right and loss or harm. Well, we have that here.
I'd object to the counsel restating...
I'm making my argument, Mr. Pierce.
You're restating
I have to go and make my argument.
You're misrepresenting my words.
You already talked. You said you
All right,
wanted to
well, here's what we'll do, Mr. Pierce. I'm going to overrule your objection at this point, but I'll give you time to...
You can't lie about what I'm saying, right?
I'll give you time to
Okay.
respond.
Okay.
Go ahead, Mr. Murphy.
Yeah. Judge, we're alleging harm here. It's in our charges, in our information, that he committed animal abuse in his sick. So, that's my point on that.
May I respond to that point then?
I don't think he's done.
Well,
When he's done, you
can I get a
respond to
pen
all
and a
his
paper
points.
so I can write down all these so I don't forget them? Do you have a pen and paper so I can write down all these points? If I'm going to be expected to remember them all.
You're representing yourself. You bring it yourself.
Without the assistance of counsel, I'm not representing myself at all. I didn't agree to that at all.
Look, Mr. Pierce, if you want to write something down, you should have brought
So
paper
just
with you.
okay, then I can't even have a pen. The court won't even offer me a
You
pen.
got-
Never mind assistance of counsel.
Officer Norman, you give him this pen.
Such easy
He
request.
already denied to make any argument in the beginning. He can't go back and respond.
Well, you can respond to anything that you bring. Go ahead. You
Yes,
can-
I can.
Hold on. Mr. Pierce.
They didn't teach you that in law
Mr.
school.
Pierce, come on.
Okay, you're right.
His second point is that there's no corpus delicti, that there's no body. Well, Judge, I believe you know what corpus delicti means, and it's just that...
Objection, can we define our terms? I would not like to agree to arbitrarily vague
It's in
stated
your
terms.
motion. It's in
So
your-
state it, sir.
Okay.
Don't
Because
restate it.
The corpus delicti is the body of the crime itself. Virtually every American jurisdiction agrees it's an absolutely essential element of any crime and is consistent with the stated purpose of American governments. In every criminal trial, the prosecution must prove the corpus delicti from the body of the crime itself, the fact of injury, loss, or harm, and the existence of a criminal agency. Judge, that's all alleged in our information. Okay, that there is a harm, that there was criminal agency here.
I understand what you're saying. Okay, anything else?
No.
There is no crime.
I gotta get...
Again, how am I supposed to respond to every... How many points are you going to make before I'm allowed to
Well,
respond?
Mr. Pierce, hold you stop.
How many
Mr.
points?
Pierce, you keep interrupting, and I've overruled your objections and
Sir.
authorized you to make a response when he's finished. On
How
your
much
motion.
time should I allow to go by before I'm allowed to respond?
I gave you an opportunity to speak. You said the motion stands on its own.
Should I wait 1 minute?
I proceeded to let him respond to your motion. I asked you if you wanted to argue anything. You said, no, the motion stands on its own. So I asked for his response. He's giving his response.
He is giving...
There's no need to object at this point. You can bring up all the points you disagree with when he's finished.
Sir,
Please don't interrupt.
I'm only
We have to go
objecting
through this.
for the efficiency of the time of the court. If he says something that I know for a fact is blatantly untrue, but I don't say anything, now the court believes that, then I have to wait for my turn, then we have to go back and correct it all. It's just so much easier if I just say, there is no victim here, a dog is not a victim, I am presumed innocent, therefore...
You need to stop talking.
Okay.
You're presupposing what the court's responsibilities are, and the court hasn't made up its mind on anything. That's why we're having the hearing. He's entitled to say things, and if you disagree with him, you're going to have to point that out when I give you a chance to respond.
Okay.
Go ahead, Mr. Murphy, finish your argument.
Thank you, Judge. Judge's third point is talking about lack of jurisdiction, saying his motion says because there's no corpus delicti, there is no crime. So that's the basis for lack of jurisdiction.
Okay.
There is jurisdiction. We're alleging that this occurred in St. Charles County, and on my previous argument, there is corpus. Paragraph 4 says that this case is not in any real sense adversary. It says if there was a true adversary against the alleged defendant, it would be laughable to try to even discuss causation because the defendant is not accused of causing anything real or imagined. And then he also, very next line, there's no adversary unless plaintiff, a fiction offense, ostensibly acting through Officer Tanner McMillan. There is no Tanner McMillan here. This is the problem with this ChatGPT. This person doesn't even exist.
This wasn't written by ChatGPT. I just told you it's 12 years old and it's been given...
Mr. Pierce, you can't interrupt him. Please don't.
Let him lie on the record. Okay.
Please don't, Mr. Pierce. You can respond.
No truth allowed. Got
I'll
it.
give you the opportunity. Please.
Got it.
And Judge, the main line here is because the defendant is not accused of causing anything real or imaginable. We're alleging the opposite, that he shot the doctor. So that's the end of my argument there, and that is alleged in our information as well.
Right.
And then the final paragraph, no evidence of presence within state and laws applicable. Is alleged to have occurred in Winslow, which is in St. Charles County. I would just end my argument there.
Great. I would like to respond when you're ready, Judge.
There is actually one more paragraph.
Oh, we're not at the end.
It says court's jurisdiction not enlarged by police authority or custom. And Judge, there's no case law or any rules that he's citing as backing this argument.
Is that it?
Yes, Judge.
Mr. Pierce, you can respond to his response to your motion.
I just want to remind the court that I'm speaking plain English here, and apparently this lawyer, Murphy, is not paying attention closely. I stated that this motion is 12 years old and has been given to dozens, I would say hundreds of judges across this country and other Western-speaking world, and judges have approved it. I myself was the first person to ever get a judge to grant this motion, dismiss all charges, even after the prosecutor argued, just like Murphy did, as to why jurisdiction, a definition he's using that does not apply here because jurisdiction has different definitions, and I'll explain that shortly. A judge granted this motion to dismiss all charges of a Class A misdemeanor and a year in jail threat, exactly what I'm fitting here today. That happened in Hilo, Hawaii, and you can call that courthouse if you'd like. So for the Mr. Murphy here to say that all these different arguments that he's using in the court are not valid because of his reasons this and that reasons this, I would subject every reason he's given to the question, upon what factual evidence do you rely to form that conclusion, or is that merely an opinion? When he says that we do have a victim and it's a non-human victim, that is problematic from the jump. Does this court presume me innocent or does it not? Because it claims to presume me innocent, but in all actuality, the way it speaks, the language it uses, calling the woman who owns the dog victim 1 in all paperwork, V1, it's prejudicial, it is biased, it is not impartial, and it favors a finding of guilty. This is self-evident and irrefutable, especially in the court of public opinion. You're having a lawyer here saying that, and this, let me make this point, and I've made it at least a dozen times in this very courtroom over this hearing, and I want this to be the last time I have to make it. Please, everybody pay attention. There is a mass confusion going on as to the word jurisdiction. It has many different definitions. Now, officers of the court are using a convenient definition of it that does not apply here, and they know in their legal training that it does not apply here, and they're attempting to manipulate and take advantage of me, who stands here without a law degree and without the assistance of counsel, by trying to conflate and confuse the issue that says jurisdiction is this geographical border issue of lines on a map, and hey, it settles the issue. Jurisdiction has another definition. Everyone here who hears my voice already knows this. I am an intelligent person who doesn't have to go to law school to be well informed as to what goes on here. Jurisdiction is the right to impose upon somebody. If you think that's foolish and untrue, let me just give you a perfect example of what the military does. As a former pilot in the United States Air Force, I can tell you that I signed a document to the UCMJ that said they had jurisdiction if I were to perform any kind of a crime or anything, whether I lived on base or off. The geographical boundary had absolutely nothing to do with it. And if I committed a crime, although the local police might temporarily have custody of me, believe you me, everything would be turned over to the Air Force or the military police. That is the form of jurisdiction I am speaking of. I am tired of people, both the judge and lawyers, conflating another definition to presume I'm meaning something that I do not mean. Mr. Murphy is attempting to manipulate and deceive this court because he knows exactly what I'm talking about, because I've had communications with him in person, left messages for him on the phone, and I visited him in his office just yesterday, where I finally got discovery, after a year of this case ongoing, finally get discovery that includes body cam footage videos that I've been requesting from day one through the Missouri Sunshine Law, a law that this officer of the court has been shirking the entire time purposefully, and he's doing that as well as anybody else of power in this courtroom is doing it, because there's absolutely zero accountability whatsoever for both judges and prosecutors in this state. How do I know that? How can I make that claim? Bold evidence. I have done an investigation over the past several months to find out exactly what happens to these people when they abuse their authority and they violate the law. Laws that are written in the hallway, statutes and codes posted. What happens in the investigation I found out by talking to the police department of several cities, the sheriff's office, the bailiffs here yesterday, the buildings across the street. I've talked to the state AG office. I've talked to the commission on the disciplining judges and removal and retirement. All of them say that that commission has the power. That commission says they have no teeth and no power whatsoever to do anything. And even though I filed 3 complaints with them early this year, I did not get answers until less than a week ago, because I've been hounding them for a month. My point is this, and I'll stop. There is zero judicial oversight, and there is zero prosecutor oversight or consequences for people who are in these positions and blatantly break the law. The jurisdictional issue has to do with the right to impose upon me, and not a geographical boundary. And I would appreciate it if every officer in this court, an agent of this court, would not insult my intelligence further by pursuing to conflate these two issues. Thank you.
Okay.
And Judge, can I just clear something up for the record?
Briefly.
Very briefly, Judge. We have tried to get him discovery on numerous occasions. We even mail it to him, that is, in the basement. So when I asked him about that address, he told me that's just the address as far as the government is concerned.
Okay, well, but that's a different issue, Mr. Murphy. That's not...
So I'm just trying to protect our own, Judge.
No, I understand that, but that...
Judge, Mr. Murphy brought up this issue of other discoveries he sent me. I have evidence right here in my hand of that evidence. It is...
Well, we're taking up your motion to strike and dismiss the complaint for the various reasons that you...
Yes, sir, but
in the motion.
I'm responding to what he brought up. This stamp
Well,
says July 14th. He gave me discovery on July 14th. That is 2 days before the July 16th bench trial date. He just gave me discovery yesterday for the hearing today. It's a pattern.
I cut him off because he wasn't...
But
that
see,
comment wasn't in response to the motion that you filed, so there's no need for you to respond.
he brought up this issue.
Well, I understand that, and I didn't take it up. I'm just taking up the motion to strike the complaint or dismiss the complaint for
May I
lack of the reasons that you cited.
I would like to respond then.
Well, you just did.
I responded
Do you have more to respond to?
I responded specifically to information that the court is required to know, record that I wanted to make so that it is aware of the abuses that are ongoing.
This is in regards to your motion to strike and dismiss.
Because Mr. Murphy brought up additional issues, I had to comment on those additional issues. I will now restrict my information to this, and I will be very brief, I promise. We're talking a matter of a few sentences. When it comes to this motion, this is a motion to dismiss for failure to strike, dismiss complaint. This goes hand in hand with the verbal motion. It is identical to the verbal motion that I have been making with you and every judge I come across on day one. And it sounds like this, and I know you remember this. You presume me innocent. You presume me innocent of every element. Jurisdiction is one of those elements. Therefore, you presume me innocent of jurisdiction. And all I've ever done is to investigate. I'm not arguing or making any claims. I'm just investigating. By what mechanism did that get switched to where I'm presumed innocent of jurisdiction, but now I'm not? And now you can impose upon me and threaten me with bench warrants and armed men that can come and extort me and take my freedom from me. That's what I've been asking. That's what this refers to. So all I've asked is, has the prosecutor provided any factual evidence regarding this element of jurisdiction that the judges, plural, presume me innocent of? And the answer to that question is no. So my motion to dismiss all charges, because of that lack of failure to file a proper case, that motion I have moved to get dismissed.
Hold on one second. We're in the middle of something. Go ahead.
This motion has to do with that. When I ask, has the prosecutor provided any factual evidence regarding the element of jurisdiction as of yet to the court, yes or no?
Judge, it's alleged in our probable cause statement that it occurred in
May I be allowed to? I can't interrupt you. You say I can't interrupt you. So please respect the same rule for yourself. Yes, I will. I will right now. Grant me a moment to retain my thought process. I'm here without the assistance of counsel. I just need a few moments. The verbal motion that I have made is hand in hand with this written motion. This motion is currently and always has been unopposed by the prosecutor. The only way the prosecutor could oppose this motion is to commit an action to provide documentation of jurisdiction that the judge presumes I'm innocent of to the court. I'm not asking what's written on it. I'm not asking is it legit or not. I'm not asking anything about it. I'm only asking if documentation has passed, if the action, a verb, has passed from point A to point B. That's all it is, and I can't get an answer of a yes or no from Mr. Murphy. If he would just say, we're using this, we have filed this. It's not the judge's job to file a proper case. It's Mr. Murphy's. My problem is not with the judge. It's with Mr. Murphy's failure.
Okay. I understand. Okay.
Judge, I would just ask that you deny the motion.
And I would ask that you grant it, and if he denies it, on what grounds? And I would ask that you respond to the motion and then oppose it.
Okay. Let me.
You can't oppose it with words.
The argument on this motion is closed. I've got the motion and I've reviewed it, and I've listened to your argument. I've listened to your response. Based on what you argued, Mr. Pierce, I'm going to deny your motion. I don't agree with you on your reasonings about jurisdiction of the case, and therefore the motion to strike is denied. The second motion was filed on July 7.
So the grounds are that you don't agree with it, sir?
I disagree with your
okay. Could you give me the smoking gun? What's the biggest point you agree with specifically, sir? Just the one specific point you disagree with.
No.
Okay.
The motion's denied. I've read it all, and
I'm not here to argue with you. I'm just recording your actions.
I understand.
So you disagree, you're shooting it down with no reason whatsoever.
Your motion to dismiss for lack of credible evidence is the other one that was filed.
I predicted this would happen. You're going to hear nothing but denials here, and no grounds given. Here it comes.
Your motion to dismiss for lack of credible evidence filed on July 7th. Take that
oh, yeah, let's take that up right now.
Proceed.
Okay, great. Have you read it?
Mr. Pierce, we've been over that.
I'm sorry. I'm not asking a disrespectful question. I sincerely know.
But really, this isn't your forum to ask me questions on what I have done and not done.
Oh, so I'll presume...
I'm the decision maker. This is your motion. I'd like to hear it. If you wanted to stand on its own like you did the last one, that's fine. If you want to argue your motion...
I don't have to argue anything.
Okay.
No, I'm not arguing in the sense that I'm not making a claim. I can respond to this motion, and I'm happy to do so.
It's your motion.
I just want you to know
Proceed.
that I'm not intending for you to take offense. I've had other judges, multiple dozens of other judges, who deny motions and don't even read them. That's where this is coming from, sir. It's not for you.
That's not the case here.
Okay, great. I'll note it.
You may proceed.
Noted for the record. Okay. Again, give me just moments to re-familiarize myself with it. It's only a page and a half. Okay. So, what is going on here is that obviously this motion was filed July 7th. Now, is the court aware that just yesterday Mr. Murphy handed me a stack of papers over an inch thick and 2 CD-ROMs? From his office, I came here myself in person.
Mr. Pierce, the court isn't here to answer your questions. We're here to answer your
Sir,
motion.
I'm not asking the question of a court like it needs to answer to me. I'm asking to...
You can point out if you're making a point.
Okay, I'll do my best. Again, I appreciate your leniency because I am without the assistance of
I
counsel.
understand that.
Okay.
I'm trying to be accommodating.
Okay. While denying you the assistance of counsel. Okay. So the motion here basically, again, I'm not going to restate the motion as in replace its words with my words, but in essence, what it states is that this motion should be dismissed, the charges in case should be dismissed for lack of credible evidence because this entire case is founded upon and started by an officer's opinion to believe the owner of the dog's opinion that they do not have a professionally trained attack dog that attacked me and opening them up to a civil lawsuit, that this dog had a ball in its mouth. Now, for the first time in my life, sir, I was finally given discovery yesterday that included details about this ball. I've never heard any other details about this fictional ball that is so important to this case. The entire case rests upon it. They say it was purple and I believe green or blue stripe, about the size of a basketball, but deflated and the size of the dog's head. I have never heard of this before yesterday. That is how flimsy this case is built upon. Police in this country kill between 25 and 30 dogs a day. And do they ever experience the consequences of having vet bills sent to them that they're threatened to pay? No. They're entitled to the cost of a new German Shepherd, not vet bills. Of the over an inch stack worth of papers that I got, only 20 pages of that about is a police report. Everything else is vet bills. Why are they sending me vet bills when I'm presumed innocent? If that dog didn't have a ball in its mouth, I'm not guilty of animal abuse. Even if that dog did have a ball in its mouth, it was in my front yard attacking me, and there exists video footage in a company work truck that the police nor the prosecutor have investigated into finding out if that's true. That video would exonerate me. It's exculpatory evidence. It would prove that the witnesses are lying. There are now 2 witnesses I found out. There's a neighbor who I didn't even know was claiming to be a witness. I don't know his name. I don't know anything about him. These are all details that were hidden from me until yesterday, and I only have them yesterday because I called the office yesterday and asked once again for the dozenth time, can I please take advantage of Missouri Sunshine Law and get the police body cam footage? Wentzville Police won't release it to me unless you give him permission, Murphy, and he wouldn't do it until just now. Not only is he only giving me this yesterday, it's because I called. He acknowledged I left a message with him Friday. His excuse was I didn't work Friday. The date on this discovery is dated September 24th of 2025, which means he made it just a few weeks ago. And despite having my email address and phone all this time, saying, oh, he just has an address from another county in Mutnell County, whatever, central Missouri, I'm just going to send everything to a random address and not even try. If anybody gets served divorce papers, a judge will have an officer of the court pay money and send a document to somebody who delivers it in person. You can't even send certified mail. You're sending address and discovery documentation to the wrong address, knowing it's the wrong address, and then telling this court, lying to it, and saying, oh, I've tried to give it to him before, he just wouldn't take it. I've got their proof right here. Mail stamped July 14th, 2 days before a bench trial. And now I get it on my own volition from him yesterday for a hearing dated today. For motion, I'm supposed to be prepared to defend today, less than 24 hours later. And this is justice. What is the court of public opinion going to think about this and the jury that will happen in a federal lawsuit aimed at this county and cities because of your actions, Murphy? File a proper case. I've asked from day one, where's the factual evidence regarding the element of jurisdiction that judge said I'm presumed innocent of? You haven't even addressed it because there's zero judicial oversight for him and there's zero oversight for you. You will face no consequences for this. This is why I called you a legalized criminal yesterday with a smile. And he said, thanks, have a nice day, and so did I. That's what's going on here. There was no ball in that mouth. That dog attacked me, and I shot it in self-defense. This is America, last I checked. Not in this courtroom, it's not. I have no due process hearing whatsoever in this courtroom, it's not. These hearings have been on motion since July, since August. I bring them up every hearing. You demand them. You threaten me with coercive threats of violence. 3 or 4 times a day, this bailiff has to be ready to arrest me because 3 or 4 times I come in here, I'm threatened. One more word out of you, and it's contempt. Now you're letting me speak. These are the words I have to say, and I would have said them on day one. How much money has the state spent prosecuting me? Former pilot in the Air Force, you think I'm going to take this? He had a judge sign a warrant to have me legally, sexually assaulted in prison under threat of a pair of scissors. You think I'm going to forget that? You think I'm going to let that go? That dog did not have a ball in its mouth. I'm sorry, I'm going to lower my voice. I'm giving this judge and this lawyer every opportunity in the world to do the right thing and look like right, ethical people in the court of public opinion. Giving everybody and every police officer every opportunity to look good. And all I'm doing is not arguing. I'm just recording. Are you going to throw me in jail for a year? Are you going to throw me in jail for 6 months? The last time I was here on July 16th, you had me arrested on the charge of failure to appear at a hearing 4 hours prior that you knew for a fact I had appeared at. It cost me $500 to get out of jail for that. And you want me to pay for a lawyer? You're having me arrested on false charges. Pick another charge in failure to appear. I appeared. You made a phone call to the other courthouse to confirm it. What am I supposed to expect? You want me to come here and pretend like this is a just courtroom and a courthouse and that's a prosecutor and that's a judge? I'm supposed to not know this is a kangaroo court? You won't listen to me, you silence me. You then pretend my silence is compliance and record whatever facts you want on the record. And then months later when you go to other hearings you say, well gee, in the hearing prior it says here what I put down. What you put down has nothing to do with what actually happened. And then I say, can I please use an audio recorder, record everything so you can't do this anymore? And you say, no, you can't record anything. Oh, you go get a recording from the clerk. They have it. I've done that dozens of times. You know what they do? They alter it. They edit it. They add background noise that makes it super loud and makes it very uncomfortable to hear. And they put it in 12 different files on a format that nobody uses, and you have to go out and search to get. This is just a small drop in the bucket of the frustrations and efforts I've had to go to defend myself in a case I am not guilty of. I have not been charged with a crime against anybody else in my 49 years of life. I've never hurt another human being, never even been accused of it. I've been loving dogs and lived with dogs. I have one tattoo. There's a dog. It's a 20-year-old tattoo. I love dogs. They've been my animals. You're saying I killed a dog? There's no video anywhere in the world of anyone shooting a dog with a ball in its mouth. It's the universal sign for I want to play. It was in my front yard. What's it doing in my front yard? It's a professionally trained German Shepherd type dog that hated me for some reason. I don't know. I have no previous history with this animal whatsoever. And look what I'm forced to endure. And it's going out in the court of public opinion. And you do what you want. You dismiss it or not. Another judge granted this motion after 16 months, and I plan on doing the same. Thanks for your time, sir. I sincerely appreciate it.
No,
I appreciate your time given me to speak. I do.
No problem.
My voice is hoarse.
I understand. Mr. Murphy.
Incredibly briefly, Judge. First of all, this motion isn't even addressed to the right court. It has Division 11 listed up top. Second of all, it's my argument, but...
I'm sorry. I apologize.
It's a motion to dismiss for lack of credible evidence. That is not a proper motion. If he wants to argue about the case, he can do it in front of the fact finders. That's for a jury to decide.
I understand.
And that's it, Judge.
All right.
It's a good old boy network. I rent a room. These people are own their home for 30 years, and so does everybody in that cul-de-sac. Where's the ring camera footage? There was ring cameras everywhere. Where is it? Where's the Burt truck video footage that proves that dog did not have a ball in its mouth?
Okay, so that is your basis for the dismissal? Is that right, Mr. Pierce?
The lack of credible evidence to impose upon somebody while you presume them innocent?
No,
yeah.
Okay.
I don't have a problem with any decision you make, Judge. I'm just here to record the results.
Well, we're doing that.
Great.
We're doing that. Your motion to dismiss for lack of credible evidence, I've read through all 8 paragraphs. You bring up some points that I think are reserved for the decision maker on the case, and that would be the jury. So I'm going to deny the motion filed on July 7th for motion to dismiss for lack of credible evidence.
You don't think there's reasonable doubt about this ball? You don't think any jury on the planet is going to see reasonable doubt that there was a ball in that dog's mouth?
You want to open up a discussion and a debate by asking the court
He agrees
questions
with
that
me.
I can't.
He agrees with me.
I can't answer
He
those
agrees with
questions.
me.
All I'm saying
Anybody
is
agrees with me.
those are jury questions.
The record is stated.
So,
You're paid not to agree. You have no ethics. You have a paycheck.
we also have a motion to vacate unlawful plea filed on July 7th as well.
Okay, so if we're moving, please let me know. I can bring up the correct motion.
Yeah.
Okay.
Motion to vacate unlawful plea.
Okay. I've never had this kind of time on the microphone. I really appreciate it. Okay, motion to vacate unlawful plea. Here we are. I'll just take a few brief moments again to familiarize myself with it. Okay, I can do so now very briefly.
Go ahead.
What I'm saying is known by every judge and lawyer in this case. And it's documented factually in CaseNet for everyone to see. No one has to believe my opinion. The issue of the plea has gone back and forth several times in this case, whether it has been entered or whether or not it has been entered. I, from day one, have fully intended to plead guilty if I could get clarification of the cause of the nature of this from the prosecutor, which I am still denied here today. Pleas are obviously supposed to be made fully informed and voluntary. Pleas are constantly being made against my will, and in this case, it's happened, I believe, twice, but the record will correct me if that's wrong. Pleas have been entered against my will, saying that I've refused to plead, when I obviously have done nothing but say I fully and willingly intend to plead guilty and pay the fine. So when this is a motion filed on July 7th to vacate the plea, at the time, it was up in the air. Who knows if the plea is entered or not? On April 2nd, there was a plea entered of not guilty. Then it was, oh, no, it's not. And then I asked verbally, and I can't have proof of this because I'm not allowed to record in the courtroom, hey, if you're scheduling a bench trial on July 16th, I said this, what plea do you have entered in the system? And I do have this recorded. You said to the prosecutor that we will file a bench trial on July 16th and presume a not guilty plea will be entered by the defendant at that time. That is a quote by you. You're scheduling bench trials without even having the plea issue addressed. And the reason why I'm so shocked, sir, is because, like you know, I've been doing this for 10 years, starting in Hawaii in 2015. And until you and Engelmeyer over in O'Fallon in the last year and a half, until you two judges, every judge I've ever come across, and every judge I've ever talked to has been come across by associates of mine, and people who pay me to teach them how to do this, has been completely obsessed with two issues. One, getting the lawyer issue addressed, and two, getting the plea issue addressed. You and Engelmeyer in these courts here in Missouri don't concern yourselves with this issue at all. It makes us wonder, gosh, this isn't America. What kind of country are you living in? Could actually go to jail for a year and not know it without being allowed to grounds to appeal or anything. We just don't know. The plea issue is absolutely 100% foundational to any right and any due process of any legitimate court. And to treat it like this flippant, well, is it guilty or is it not guilty, it's only done so to avoid the exact motion that you just denied. The plea is up at issue because I'm willing to plead guilty if he can provide factual evidence regarding the element of jurisdiction that you presume me innocent of. He will not provide that. He will not provide anything whatsoever, and yet that unopposed motion, he can oppose it all he wants with words, but he can only oppose it with an act and a document, really, is completely ignored, and the charges aren't dismissed. The charges should be dismissed because of this failure to provide evidence of jurisdiction by the prosecutor. Military courts provide it. Religious courts provide it. International courts and human rights violations like genocide provide it. Jurisdiction is a foundational institution. You can't presume, oh, it has to do with a geographical fence. This happened in Wentzville. Case closed. But it's not the definition I'm talking about, and everyone knows it. That's what this came from. So the motion, whether you grant it or not, the plea is still up in the air. We don't know still to this day if it's not guilty or what's entered. But this was filed on July 7th. That's why, and it's been ignored until today. If it was taken up by you on July 7th, it would have been completely relevant at the time. So what is the current status of the plea, according to the record? I don't know at this very moment.
Any response?
Judge, I think mostly this is addressed to the court, and I don't have a response to any of the paragraphs.
Okay.
This is going viral. I can't wait. I've never been able to
Judge,
see
did we
this.
permit recording devices devices.
I have a memory, sir. I have a memory. My memory is ironclad.
You're not recording on your phone?
For full disclosure to the court, it does appear that he's got some sort of recording device sitting on the podium.
Officer Norman, will you look at that for me, please?
For full disclosure to the court, it does appear that he's got some sort of recording device sitting on the podium.
Officer Norman, will you look at that for me, please?
I do believe that might be recorded.
I have emergency people that can call me. I have to be able to have people call me.
Just power down the phone. That way there's no issue. I know that you're not recording. That's not allowed.
Yeah, I mean, I don't know what that device is they're examining.
Yeah, he was recording.
No,
You just put saved on it.
no, I didn't. Look, I can't even see it with my glasses. There is no save. Look. Look, here, look.
Mr. Pierce, if there's a recording.
I asked you if I could record in the beginning, and you said no, so I didn't turn it on. Look, do you think I'm going to risk going to jail for this?
Overruled, and you're not allowed to do that.
Okay, so I'm not recording, so everyone knows I'm not going to jail for this.
It's okay if I send it over here.
No, it's my property. I want it, but I'll put it in my pocket. I don't need to touch the buttons on it or anything. Look, turn it on. It's not recording. You can see, and I'll put it in my pocket. I don't want the government to have my property. I never
Put it in
have
the
to.
back on the. Just put it on. Just put it on the table. Officer.
Perfect. Great. Perfect.
Okay. So I've heard enough argument on the motion to vacate plea, the unlawful plea. The court has read through all those paragraphs. I think it was seven. Mr. Pierce, the court is going to disagree with you that you did enter a plea of not guilty. And I'm not going to vacate any unlawful plea because I don't see it on the record. I think the record speaks for itself. So that motion is denied.
What plea is in the record right now?
That motion is denied, and I've got to take a quick break and do this.
I've got to use the restroom. Can I take a break as well?
You can go to the restroom.
What motion is in the record right now? Is it the motion guilty or not guilty, or no motion, or no plea at all?
I mean, what plea of guilty is this?
What plea exists on the record right now?
You can take a break. I've got to take this. Okay, ma'am, your name? I think out of the abundance of questions, Mr. Pierce, any electronic or gun should be placed over on the table or on the chair.
That would be my phone.
Yeah.
Okay.
Whatever the smaller device, you had another device.
Yeah, I just gave that to a friend.
So you don't
Look,
have
I
that
don't-
on.
I'm talking about the recording you guys are making. You told me I could pay money and go get a recording of this hearing, right? Why is there a question about secretly recording? I'm not recording. I'm kidding. You're
You
recording.
keep answering my questions with a question, and that's not the way this
I
works.
know how you feel, sir.
You
I know how
can't
you
do
feel.
that. So, okay, you're telling me you don't have anything else on?
No.
And your phone is off.
This is
Your phone is off.
It's on silent. It's not recording.
Okay. All right, then you may proceed with your
What am I going
motion.
to do? A search and seizure here, right? Okay,
Proceed with
great.
your motion. Motion to dismiss due to prosecutorial
Allow me a
misconduct
moment.
filed on July 15th.
Okay, let me collect my thoughts here and get the right motion. Sir, I'm 100% going to address that right now. I just want to give one page to you and the lawyer here. This is something I filed this morning. This is just a list of 11 issues I would bring up if given the time. You are allowing me the time to address them all. This was filed, and I wanted to report this is what I want to accomplish if given the time. And
So what you're telling me is you filed another motion and you want to take that up right now?
I filed not a motion to ask you to compel you to do anything. It's simply a notice of the issues that I would request to bring up to discuss here at this pre-trial motions hearing. And it was on the fear that I would not be allowed to speak. I would be threatened with contempt.
I'm not going to take up any new matters until they're properly filed and noticed up according to the rules.
I just noticed it.
If the rules say you got to give them a little more notice than that.
You're talking to a man who gave me discovery yesterday. You're not serious when you say that, correct?
Look, you're answering my statements with a question. You're not answering.
It's the proof of
The rules say that you have to file a motion if you want something heard.
Sir,
You're talking about a discovery issue. That's not what we're talking about. I'd like you to proceed on your motion to dismiss due to prosecutorial misconduct so we can get through these.
Okay, speaking of prosecutorial misconduct,
Very good.
this man has a habit of giving me discovery days before crucial hearings and not until then.
Okay.
He waits until the very last minute. Twice now, I have proof of this,
Okay.
in hopes of catching me unprepared. Here I am, without the assistance of counsel, as I am guaranteed the right to, and he's doing this on purpose. It's only when the date of the trial is very soon that he will actually respond to me. Keep in mind, sir,
Okay.
I have left a voicemail at least once a month with this office for over a year. I have another motion here that you can see that is before you of an email chain of record that I have ongoing with the records department of the Wentzville Police Department, who has told me that it's this man's permission and only this prosecutor's office permission that will allow them to release the police body cam exculpatory evidence to me in the first place. He has denied me the ability to see that in accordance with Missouri Sunshine Law that states he is required to give this to me. And even this morning, you won't believe this, Judge. I emailed the records of the Wentzville Police Department just last night after he gave me the CDs that he claims to have the police department video on them. I said, your boss just gave me the video I've been asking for all this time. I would like to get your copies as well. And I kid you not. This is in an email, so I approve. She said, we're still not going to give it to you because of some Rule 25 that says we don't have to give it to you until after your case is over. Their rule says that I can be found guilty and punished before they're allowed by their rules to hand over exculpatory evidence. If that is not a legalized crime, I don't know what is. I am being imposed upon. $3,000 is out of my pocket. I've been incarcerated for 80 hours under torturous conditions as defined by the UN, not me.
Give me 1 second. Go ahead. Keep going, Mr. Pierce. I think I understand you right. Your motion to dismiss is based on the lack of his forthrightness in turning over discoverable evidence.
If he would have done so in the beginning, all charges would have been dismissed because they would realize you can't depend on the opinion of the dog owner to found an entire criminal case on and then say there's a victim when there is no victim. That dog attacked me. It was a perpetrator and I shot it. And I would do so again. And I love dogs and sleep well just fine knowing I shot that one.
Okay.
I'm glad it's alive, by the way.
All right. Now,
He
you
just
think what you're saying.
purposefully ignored multiple messages so I could get this exculpatory evidence and clear, because apparently I have to prove my innocence. He knows he doesn't have a burden. He's acting as if there is no oversight whatsoever or consequences to his actions whatsoever. I've already spoke to the state AG about this man, and they say he's not doing anything wrong. There is zero oversight. My job is, yeah, he shook his hand and cheered. Just now he made a motion, yeah, the state AG agreed. Guess what? They didn't say that, sir. I just made that up. They didn't say that. I
Mr.
just
Pierce,
made that
has this
up.
got anything to do with your motion to
The
dismiss?
AG never said that.
Mr.
They
Pierce,
told me
let's
they have
get back
the
on track.
review.
Mr. Pierce, please, I've got to interrupt you. You're kind of going way off the tracks.
Yeah.
Get back to your motion. Is that it? You want anything else for me to consider on your motion to dismiss
Well-
due to prosecutorial misconduct?
Yes, one other thing I'd like to mention.
Sure.
In this very room, the very first time I was able to speak words with Mr. Murphy, who won't return my phone calls despite having my email and my cell phone number, I questioned him while I was being arrested by this kind gentleman of a bailiff in that corner. And Mr. Murphy was standing right here. And then I was like, oh my gosh, this is the first time I've ever gotten to speak to the prosecutor in this case, who's totally ignores me and won't talk to me at all. And what did I choose to say? I said, Murphy, why haven't you had the police get all these Ring camera videos from all the houses that surround, that they protect Amazon packages? They totally would have caught the dog attack. His response was, it's not my job to police the job. It's not my job to police the job. When I made a complaint just recently, about a month and a half ago, with the Wentzville Police Department of this dog owner is coming out to her front yard with nothing but a leash on this very aggressive and barking dog at me when I come out to go on a bike ride. I had to not go this way past her house. I had to cut across other people's yard to get out of here because it was only her hand that was holding this dog. It was barking again. She's trying to intimidate me. I have documentation of this with Wentzville Police. I left, and all that behavior on her part has stopped. But what my point is, they said, Michelle Witt, the records department said, would you like an officer to come out and check all the Ring cameras? Maybe they caught it on video. thereby admitting that that's standard protocol for crimes that are committed in areas like this. And why they haven't done it? Again, because it's a good old boy network. These people know the police, and they're all in collusion and conjunction with each other. That's why the police body cam footage videos have been delayed, even being allowed to come into my possession in violation of Missouri standing state law. This shows a habitual pattern of deceit, of imposing upon people who are presumed innocent. And by the timestamp on this mail, it's showing that he's only given me discovery twice. One of their own volition on July 14th, 2 days before a bench trial that was changed to a jury trial. And the second time was yesterday because I called him and went there and got it. This is from an office that has an utmost requirement to do what? Provide discovery to the defendants. He knows, everyone knows there was no ball in this dog's mouth. He knows I'm innocent of this. That's why he's avoiding it like it's an unpleasant task he has to do until it's the last minute and he can procrastinate it no more. That's what's happening here. So, and I accept your ruling. Please go ahead. I'll stop talking. Thank you for listening.
Any response, Mr. Murphy?
Just briefly, Judge, I'd just like you to take judicial notice that standard discovery was filed with an itemized list. It's in the CaseNet docket entries, and the letter says it was sent out like June 26, 2025. And that was to 501 Northview Court in Winsville, Missouri, 63385. So we have attempted to give them discovery.
It's not through certified mail. And what is on the record is them sending documents to the wrong address. It's on record, them sending documents to the wrong address and having it returned to them.
All right, let him finish.
Okay, good. And also, as for what's actually listed in this motion about ring camera footage, we've not been sent any ring camera footage. We don't know that there's that even for this. Whatever I have, I turn over.
You turn it over.
Yeah, and I did all that yesterday. I made sure again. Not only did we attempt to give it to him once, I physically handed him the discovery yesterday with an itemized list of everything we had. As for body cam footage, that was turned over yesterday and was attempted to be done by mail already on CD. It says in that letter on June 26th.
Okay.
As for 911 call recordings, there's nothing in our discovery. I asked our investigator to see if that exists.
And
if it does exist, he'll be given it at the next pretrial.
And the jail cell video?
I think you have on November 12th. He'll have it then.
The jail cell footage of all moments of me in their jail? Yeah, I would like that too. With no padding and no bed to sleep on, strip naked. I'd like the jury to see that too.
Is that it? You're
Yes.
finished? Okay. Mr. Pierce, you need to add anything he said? I mean, I think I understand what you're saying.
Because I'm not allowed to respond immediately when he tells him this truth, you're relying upon me to have an instant memory to remember everything he said and then to regurgitate it for you for the record. That is not how normal human conversation works. You need to allow me to object. That's why we have objection, point of clarification in this law system. Object and respond to them individually. When you wait until he finishes at the end of several minutes and ask me to respond to each point, I'm not going to remember every single one. And this is why you need to allow me to respond very briefly to everything he says that I feel is untrue.
You just talked for 15 minutes.
If
You
you
didn't
were,
respond to everything you said. That's
are you asking to? You're not asking to. You're not. You're in the position of power. You're being favored by the power. You're not being opposed by the power. That's obvious to everyone who isn't you and paid by you. State of Missouri.
Anything else, Mr. Pierce? And I don't think. Oh, go
I
ahead.
know. I really. If I had any hope whatsoever that there was impartiality here and that you were going to grant any one of these motions today, I would have more to say. But I don't have more to say because I know you're going to deny it without grounds.
Okay.
There will come a time when these legalized crimes are recognized as such. It might be 10 or 20 years.
The court has
Probably
reviewed
half.
the record, and your motion to dismiss due to prosecutorial misconduct is denied at this time. He's turned over the evidence. There's something else that he has to turn it over, and he's telling me he doesn't have it.
You're not going
So
to
that
punish
motion
him.
is dismissed, or denied.
You're not going to punish him at all.
Is the motion to compel disclosure of exculpatory evidence, I mean, that was very similar to your.
Sir, my issue is the length of time that he has waited before giving me discovery documentation, and he hasn't even provided certified mail. He hasn't paid anything to get a signature of somebody that could get something to me, and yet he's been given my cell phone and email address this entire time. It was only because of my phone call that I went and got discovery from him yesterday. If I didn't make that phone call, I would have never gotten it yesterday, and I'm standing here without it at all.
Okay.
That would be his pattern.
Right.
And I'm asking you, I'm not asking you to judge, has he given me discovery? Clearly he gave me a bunch. My issue with you is he took forever to do it. Make the state spend all kinds of money to prosecute a case that should never be prosecuted in the first place, where all charges should be dismissed on flaky foundational evidence.
I understand your complaint,
Yeah.
and I appreciate what your argument is
So can
on the
you
length
please-
of time issue.
I don't want to do this to anyone in the future. Can he please be expected to respond within a month of full discovery like he just gave me? I need this on month one, not month 13.
You've requested a motion to dismiss, it's been denied. Let's move on to the
Okay.
motion to compel discovery of exculpatory evidence. You may proceed.
Motion, say the title again?
Motion to compel disclosure of exculpatory evidence
Okay.
filed August 25th,
Oh.
2025.
Okay, we're moving dates. Let me adjust her. Okay. I'll put July 7th away. And I'll pull out August 25th.
Yeah. Do you need a minute?
Yes, I do.
Are you Mr. Best?
Oh, great.
Okay, Mr. Best, are you able to make bond in this case? Looks like this is a probation revocation from a while back.
It's all the same. I know what all this is. Okay, we're good.
Prosecutor have a position on this case.
Judge, I saw a number of violations.
Right, but is there a recommendation? I mean, the PO is recommending a conversion to an SES, a new term of probation.
I understand that. I would need to talk to him and see if we could resolve some of these probation.
What is his bond currently?
I knew you were going to ask me that. 21, 4, 6, 35.
Mr. Best, do you have other cases pending?
Judge, his bond on this one is $500.
Can you post the $500 on this case? Okay, you got other ones that you're not able to post bond on? Okay. Are you requesting jail time on this
Judge,
case?
so here's what my offer on this. I think he's been in jail for 8 days so far. If he wants to confess the violation and have his term of probation revoked, I would offer time served.
Okay, Mr. Best, the prosecutor in court has offered you that if you plead guilty to or confessing the violations of probation, they'll convert the case from an SAS to 8 days jail and give you credit for the time served, and that would make this case over. I would need to caution you, you don't have to make that decision today. We can set the case for a probation revocation hearing. I understand you're in jail on these other cases, so you're not going to be released regardless of what we do today. But because he's offering you a jail sentence and credit, you can definitely apply at the public defender's office if you want to. I'm giving you that opportunity because if that's what you want. You want to talk to a lawyer? Oh, you do? Okay. All right. Well, then why don't we just continue this? Can you get him in the case? I don't see anybody in. Tell him that the case is going to be put on the docket for November 19th. All right? We'll see you then. Thank you. Sorry about that, everybody. Mr. Pierce, go ahead when you're ready. We are ready to go.
Here it is.
Additional issues other than what we talked about, I assume.
So these are motions from August 28th, correct?
This says August 25th, 2025, motion to compel exculpatory evidence.
Okay. I can,
Now, it looks like you've got some of this evidence?
yeah.
Okay. So, you still want to take it up?
I'm about to give you an answer about just that,
Okay.
to make things
Take it
easier.
up.
I'm following you where you're going here. Okay, here we go. So I have a copy here, motion to compel discovery of exculpatory evidence. This is a Brady request. I had to file a Brady request on this gentleman to get him to give me the discovery of exculpatory evidence. Now, all I need to address on this issue, sir, is that I want to make the court aware that because I was given all of this yesterday, and because computers not sold with a CD-ROM these days, and I was given CDs, I did not have the time to view these police body cam footage. I highly suspect that it has been edited to remove incriminating evidence of collusion between the police and the owner of the dog and their family. I would, and again, simply making records, but I have not seen it. Because of the suspicion I have, I would very much requesting that judicial notice be made that my request for this body cam footage is from the moment the police arrived in the cul-de-sac to the moment they left. All conversations are relevant to me. I am alleging collusion in a quote-unquote good old boy network, and if they think that, oh, well, this isn't relevant to him or that, they're going to go ahead and erase it and mute it or whatever. This has to do with private information. Whatever rules they have that nobody knows about, accept them. I don't believe that the entirety of the police body cam footage is going to be revealed in what they gave me. So I would like to reserve this motion and put it to the side. I suspect that I'm going to have to file another one just like it once I do have time to review the police body cam footage. Have I made my intentions clear? Do you have any questions for me?
No, I understand what you're asking.
Okay.
Any response to what his request is?
Just briefly, Judge, I think the motion should be denied because you can't, nothing should be compelled what I've already given.
Well, I don't know that I agree with that, but what I don't want to do is I'm not going to reserve the motion. The motion as it stands, and I've read the motion, is going to be denied. Now, if you review the evidence, Mr. Pierce, and you think that there's something that's been altered or missing, you can file the appropriate motions.
I find that fair. I find that fair.
Very good. Thank you. I believe that's all 5 motions.
Well, there are 4 from July and 3 from August 25th. And 1 from this morning, and I have hard copies of the one. I can give it to you right now. Now, I don't expect you to be prepared for or deal with it today, but I can give you a copy of it. May I approach and hand you copies of the motion I filed this morning?
No. No, if you filed them this morning, they'll make it to the court file. I can't take that up right now.
I don't want you to take it up, sir. I don't want you to take it up. I just want you to take the hard copy, but not take up the issue.
No, I'll print it out when the clerk processes it, puts it in my file. Okay. July 15th, August 25th, July 7th.
There's the list here that I also filed as part of that motion of 11 items I want to make sure are addressed today. Can I have you a hard copy, 1 page of these 11 issues? You can throw it away in the garbage if you want to.
7. Is that something you filed today?
Yes.
No, I'm not going to take that up today.
Okay.
You have to give a copy to Mr. Murphy and notice it up according to the rules. Okay, and that was also 7. So we had 7-7, 3 motions on 7-7, 1 motion on 7-15 that we took up in this motion that we just took up on August 25th that was filed. I'm not seeing any other motions. Am I mistaken?
Yeah, I'll bring them up. I have them right here, and they're stamped.
If you filed them with the court downstairs, then I'll get them.
Yeah, I have them. They're filed. It says right here, filed.
Oh, yeah, and then that's fine. They haven't made it to the court's file.
No, these are August 25th motions, sir. August 25th. They're the ones that I'm showing you that you don't have on record, apparently. But I checked pasting that this morning. They are filed.
Let me look.
You have to expand 1 line, and it drops down to 3 blue.
I understand.
Okay.
Look on August 25th.
Yeah. This is my motion I filed, the defendant's record of attempted contact with the prosecutor's office. Exhibit A. Building a case here. These guys are withholding exculpatory evidence.
That was part of your motion to compel though, right? The exhibit A and B?
Yeah.
Okay, so he just denied it.
I would not speak for the judge if I were you. This is a completely different motion that doesn't have anything to do
Exhibit
with
B is the email chain, and Exhibit A.
Yes. I'm just making record that these were received by the court. We're acknowledging them here in the courtroom.
No,
They don't.
right, correct.
I'm not trying to compel you.
No, I understand what you're saying. I get you.
Just make a note.
No, I understand completely, yes. That's part of the motion that was filed on the 25th.
Yes, this all shows a documented history of the lengths I had to go to just to get the police body cam footage in accordance with Missouri Sunshine State law from this county, from that prosecutor, and from the city of Wentzville. Their complete inability to pass it off and using Rule 25 shell game to prevent me from having it so that they don't get sued in civilian court.
I understand. Okay. And the court is going to keep the ruling as denied based on the reasons that you put in your motion that the court disagrees with. So that's going to be the ruling on the court. Our next court date will be November 12th, unless there's other motions that are filed and noticed up before that date. They're free to do so.
There are. The one I filed this morning, and I'm saying one here.
No, you have to file them in accordance with the rules and get them noticed up.
Yeah, I just did.
Okay, very good. Anything else, Mr. Murphy?
Just one thing, I would just ask for an updated address if we do need to send him any additional discovery.
Absolutely. Mr. Pierce, if you're living in a different, he needs to know where to send stuff. Correspondence or discovery.
He needs to call or text my cell phone or to send me an email.
Well, wait a minute. Mr. Pierce, you're here in court. You can give him your address while we're here. Let's be candid with each other and not play games.
We're not playing games at all. Here's a piece of evidence of something he's already sent me. I have it in my hand. It's addressed to 501.
Is it the proper address?
Yes, 501 Northview Court. Now, I can get it if it's sent to this address.
Mr. Murphy, does that satisfy your request?
Yes, sir.
Okay, then we're good.
That's right.
Okay.
But what he hasn't done, I would like the court to require him to use certified mail, to get a signature, to get something, because otherwise he's just saying, oh, we sent it, my obligation is done, and now you're screwed. That's the reality of his world compared to mine. I would like the government to have proof. It's so cheap. Have a signature be required. Send certified mail if he's going to send me anything.
Your oral motion to request that is denied. We are concluded for today. We are off the record.
I'm not done. I have my list of 11 things. I still have issues to talk about. You're not listening to me. And I warned against this by filing this motion this morning, thinking you would do exactly what you just did. I did prematurely.
Mr. Pierce, I didn't end anything prematurely.
There are relevant issues on the table.
File new motions. You can do the appropriate thing.
I'm not here to argue with you. I'm just here to get you.
But you are arguing with me. And
well, I'm not anymore.
We're done.
We're done because you say so, and you have the armament with a gun, and I don't. That's why.
That's not the issue.
That's why we're done.
No, we're following
you have
the rules.
The guns, and
we're
I don't.
Following the rules. I don't see any other motions.
The rules
were
are
properly noticed.
Guns.
Pursuant to our last court appearance.
It's
Thank you.
That's
it, Mr. Pierce. Please, you're making this more difficult.
All I'm saying is the gun in the
You can defend yourself any way you like, but you've got to do it within the rules. Okay, we're done.